going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you guys are having a great day so far. Happy Friday. We made it. It's the end of the week. Yeah, it's Friday. Oh, man. Today was a long day. I spent almost all day in Judge Simpson's court watching 3 cases. I'm about to show you those. I changed what I was playing tonight about 12 times because the last case of Judge Simpson's day just would not stop. But it was too good. I had to add it. It ended up being, it was like 40 minutes long after editing a lot of the pauses out. So, yeah, we're going to hang out in Judge Simpson's court all night. Yeah, which is good. That means I can save the rest of the content I gathered today for the weekend. But, yep, Judge Simpson. We've got 3 cases. And a mother evicts a daughter. We got the weirdo dude that got thrown in jail last week. And then we have the Hailey update. That's tonight's docket. All right, let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Now let's go.
Lisa Anderson versus Larissa Anderson. This is going to be a minute.
Hello.
Hello. That's okay if they're backwards. Your name?
Larissa. Lisa.
All right. Okay, this is a termination case, and as I'm recalling, mother-daughter. Is that right? Okay. Is it your house, ma'am?
Yeah, I'm on the list too. So we're both on
Okay, are you renting this place from somewhere else?
Yes. It's an apartment.
Okay, so and ma'am, let me ask you this. I don't have a copy of the lease. Are you disputing that she's also on the lease to the apartment?
No, I just wanted her out for my well-being.
No, I hear you, but I've got to have a legal basis in which to do that. So you're both on the lease to the premises. Is that correct? So you would agree that Larissa,
Her
right?
name is on the lease, yes.
That both of
She's
you are
over
the,
18.
pardon?
Because she's over 18, yes, she had to be put on the lease. The Section 8 housing voucher is in my name. And they told me since she won't move out, that I have to evict her.
Oh, boy.
Yeah.
All right. So you've got a leasing agreement. There's a Section 8 voucher. What is the portion of, so how much do you pay?
I pay $374 a month.
And the voucher takes care of the rest of the rent.
Correct.
How much longer is the lease?
The lease ends in February.
And so of the,
All right, quick question. I don't know all the rules to Section 8. I've never been on it before. I've known a few people that were on it, but I never questioned it. Don't you have to have kids though to be on Section 8? The kids have to be living in your house, apartment, whatever. to get it, right? I thought that's how it worked. So if she evicts her daughter and she's there by herself, she wouldn't have Section 8 anymore. Again, that's just how I understood it worked. I could be way off, but yeah, that's how I understood it.
$300 something. Who pays what? Do you pay that?
I pay everything. I pay the lights, I pay the water, I pay the rent. She just comes and goes as she pleases.
Okay, pardon?
I stay there. I live there. I buy household needs. I buy the soap, the laundry. I buy the needs for that.
Okay, I got you. But if you don't mind me asking, how old are you?
I'm 22.
All right. So
A single mom with my kid.
I got you. Who also resides there?
Yes.
So what's your position on this termination? You don't think you should have to move? Or what?
I mean, she's my mother. We never like agreed on. It's just rent. She wants me to pay, and she wants me to get out. I don't understand why I need to get out. She's my mom. I mean, we've only had each other like for all of our life. And when my dad kicked us out, it was her and I homeless, like at a hotel and things like. And now she's trying to kick me out. I don't know why she needs to do that. If the lease is up in February and we both have to leave in like February and like right before the holidays and everything, like. I don't know. First she tried to take guardianship of my son, and then I'm not dead or like running away. I'm not missing. I'm here taking care of my kid. So that's why I had my kid and she got denied. And now she's trying to evict me because she didn't get lands. So it's just a whole situation, Your Honor.
Yeah. So here's the thing. You mentioned twice her being your mother.
I love her.
Pardon?
I love my mother, but I don't think the roles are, I don't know.
You don't think what?
Like, I don't think she loves me the way I love her.
Okay. A lot of powers come with this robe. I can't make people love each other.
Right.
So, or how they do it. But why do you want to kick your daughter and your grandchild out?
I'm not trying to kick my grandchild out. It's my daughter that needs to go.
Because I don't.
Okay, but whoa. But
I know technically it is.
that's a package deal.
I understand, but she.
So then my question is, why would you want to do that?
I honestly don't want to do that, but I need this because she's abusive towards me.
Okay. Larissa, you don't have a place to go with your child. Is that correct?
I mean, I really have to find a place, but I want to stay with my mom, and I'm not abusive towards her. She wakes up and
You
she
just
starts.
got my hand. You did
You
this
did
to me
that to
on
yourself.
No, you did it to me on Sunday,
I did
Larissa.
not do that to you.
All right. So if there's any type of violence or anything like that, then somebody needs to call the police, because that's not what I'm here to deal with. I'm here to deal with.
I understand, but she just thinks that I'm going to keep my mom close.
She just thinks what?
Yeah. At the end of the day, she doesn't need a reason though. If her name's on the lease and well, no, she said the daughter's on the lease too. No, I think that changes things. I think she needs a reason. Yeah. No, good point.
She blames me for everything, and she doesn't make she doesn't.
She says she doesn't do anything wrong?
She just needs to go.
Ma'am, and I don't mean this flippantly, but it's just true. A 22-year-old daughter telling you that she doesn't do anything wrong is absolutely normal, even if they're doing the wrong thing.
I understand. I was 22 once.
I know. And you know that you may just be doing the silliest thing in the world. The adults, the real adults, are all looking at you, but they will swear up and down that what they're doing is the right thing. That's just the nature of a 22-year-old. So let me ask you this. If I were to make a determination that it's a joint tenancy, which it is, and so that you can't evict her, what are you going to do?
I already told her that.
Well, ma'am, did I ask you? All right. So that was a 22-year-old thing that just happened there. Do not talk. Do not talk. Do not talk. What would you do?
I don't know.
Pardon?
I don't know what I would do. I guess I'm stuck with whatever your judgment is.
Yeah, you may be, but that's kind of what I'm getting at. What's your backup plan?
To find my own place and move out.
Okay, have you done that?
No, because
Because why?
the voucher's in my name. I'm stuck in this lease until the 18th. She has no way of paying it. She doesn't have a job.
Have you asked Section 8 about moving?
I had talked to them about it, but they said that I have to contact the landlord where we're living if they would let me out of the lease early. And no, I have not.
Did
done
you
that.
talk to them?
No, I have not.
Why not?
Because I asked them to help me evict her and they wouldn't help me do that. So I don't know.
What, Larissa, what did you want to say? What?
I don't remember.
That was 22 also. All right.
She wanted to work on things with us. She wanted our relationship to get better, and she wanted me to see her therapist. And I'm open to seeing her therapist, but I don't think he's like all there. But I'm like, whatever.
Well, okay.
We'll make it
Let
work.
me just tell you this, because here's what I'm going to do. I'm not going to give you guys my decision today because I don't think you guys are ready for the decision. You haven't explored all of your options and what they do. You haven't explored necessarily all of your options, but you are going to figure out a way to make do. Right? Now, I'm just going to tell you this, and maybe the two of you ought to think about some of these things I'm about to say. Larissa, you tell me you love your mother. Sometimes you have to meet them halfway. You have to have maybe a greater understanding of where they're coming from and whatever. Sometimes that can be, particularly for a young person, it can be grueling because you don't understand why they may be operating in the world that they're operating. But you just have to do it. And you have to go through time. And if you got to go talk to somebody to try to understand maybe what she's saying, that's what you got to do. Because guess what? In the end, you get one. That's all that you get. And young lady, while young people don't think that They think they got all the time in the world and can do all of those things. You get one, and if you blow it, there isn't another one to come along. Right? And from your side, your son's name is Lance. He gets one. That's it. Now, for you, and I don't mean to say this, I probably you're going to get in some trouble, but daughters are challenging. I will just tell you that. I've got one of each. Daughters are challenging. The boy was a lot easier for me. My daughter's 26. I still don't understand. I listen, but she's going to operate in her way. And when I tell her, you've got to meet your mom halfway or try to understand, you know what? You just have to be quiet. That's part of your damn problem. Excuse my language, but it's true. You have to just shut up. Because I bet you, you've interrupted me twice, and I can bet you when your mom's trying to explain something, and it may not come out as articulate as she may want it, she may not even fully understand the emotion that she's trying to explain to you, you probably don't shut up and listen. You ought to try that. It can be cathartic. If you love her like you have proclaimed here, you would do it. Ma'am, sometimes you just have to understand. That's a whole different generation than you probably grew up. Her whole thought process is just different. And you can see it just by what's happening in this courtroom. You have not once during this proceeding interrupted me at all in terms of what I'm saying. This one, it's been at least twice. You may not like it, but in some ways, that is what it is, at least at this.
Yeah, you're absolutely right, Lazy Buffalo. Everyone in the courtroom was like, oh man, I don't want to go next. And throughout this entire thing, poor Hailey sitting there in the courtroom. The only side of Judge Simpson that she has seen is the nice, compassionate Judge Simpson. She hasn't seen the angry Judge Simpson, and she got it twice today. So yeah. All right, let's go.
You have to accept the fact that if you offer for ways for her to engage and she doesn't want to engage, while it hurts, you just have to let it go and you don't try to force it. Because if she doesn't understand that she doesn't get another mother, that's not your problem, that's hers. You got me? And it sometimes, I see it all the time, it can be one of the most painful things in the world because that person in front of you is at least half you, and you can't believe they're acting the way that they're acting. And it hurts. So what I might suggest, if your mother is offering that you go to counseling, whatever you think of that person, whatever, maybe you show the gesture to your mom and go. So here's what I'm going to do, ladies. I don't think this is going to be sorted out in any given period in time, but I'm going to give you at least a week to try to figure it out, act like grown-ups, and maybe the two of you, and I'll say it this harshly, maybe the two of you should stop being so selfish and think about that little guy, Lance, and think about that he's got these two women there that he's got to figure out what they are, and neither one of you are acting in an appropriate fashion for him. So I'll see you guys in a week, oh joy, at 2:00. Start acting like adults, figure it out, come back and tell me something. Wait, what?
kid says school, and I have to pick him up.
2 o'clock. Figure it out. Next Friday, 2 o'clock. Figure it out. Have a great weekend. Seriously, you're gonna walk ahead of your mom? Thank you for opening that door. Cause otherwise I was gonna have somebody come out there and snatch you up. You just no, quit talking to me. Jeez, Pete. If my daughter did, that would not be a civil case. The first two?
Yes. If my daughter did that, it would not be a civil case. That's funny. How many times I've said that line before? Not about my kids, but just in general. Like if that happened to me, nope, wouldn't be a civil case anymore. It would now be a criminal case. All right, let's move on. We're sticking in Judge Simpson. This next guy. This is the guy that got arrested last week. Is it last week or 2 weeks ago? I don't even remember anymore. Everything runs together. But he's the one who started fighting kind of with everybody. Turns out he had a bench warrant for his arrest for failing to appear for traffic court. So he got taken into jail in the middle of a landlord-tenant case. It was kind of funny. Sad, but kind of funny. Before we go, Michelle, thank you. 10 months. That is awesome. You're almost at a year. Thank you so much, Michelle, for the 10 months. I appreciate it. Okay. All right. This next one, man. grab your popcorn and your Coca-Cola and relax. This entire case is just wow. I also want to say Judge Simpson was on the bench till 6:30. 6:30 is when this case ended. On a Friday. That's how long this defendant had him in court.
Court calls the case of River Ridge versus Timothy Kelly.
Rachel Dornbush, Your Honor, on behalf of the plaintiff.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
No, sir, that picture is not going to happen that way. You're not going to sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kelly.
Okay. Come on. Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right. I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, that's why I know I missed the trial, but there's all kinds of reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions, and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
Sir, I have read everything
Okay.
that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties
Sir,
know.
what are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing,
Heather.
all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Deep breaths, Your Honor. Deep breaths. The way that he just responded, what? No, this is not going to go well. You can already see it. It doesn't. It's going downhill right now, and it's just going to continue picking up speed.
Do not come here.
What?
At this hour, questioning me about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here. They've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case, and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor. Please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're going to have a problem. Will you throw something down again, we're going to have a problem.
Sorry.
Sile fire.
Oh man. That was just part one. There are 3 parts to this hearing. Sit down, shut up. All right. Part 2. Let's go.
Retry this. Court recalls the case of River Ridge versus Timothy Kelly.
Yeah, he did. He tried these same tactics the last time he was there. Ended up having a bench warrant, so he was thrown into jail. But then he was scheduled for a bench trial that he didn't show up in. He didn't show up to the bench trial. So he gets thrown in jail, gets released from jail on the exact same day. Supposed to have a bench trial the next week, doesn't show up, and now he's here today. Just no. Yeah, I don't even have to say anything. That's not how you do your words.
This is your motion to set aside the default judgment. There are two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with a friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some.
Sorry for the interruption, guys, but yeah, Jay, that's a great reminder. Please, no spoilers. I want to watch the fight after my stream's over tonight. So if anyone is watching it or does watch it before the end of the stream, please, no spoilers. I will be very upset if someone starts spoiling the fight. Let's just say that.
Some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke, and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because it has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And
Your Honor, I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that conversation happened.
I thought at that time that it was
I'm not going back over this.
Your Honor, if you would listen if I could cross-examine witnesses and bring my witnesses in you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there, and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Colin.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, and they're all filled up. I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well,
Did he just try to gaslight Judge Simpson? That's a first. That's a first. I really want to say this, but I'm afraid you're gonna be mad at me if I say this. Come on, man. Like, who do you talk to that works on?
I had all kinds of things written down. I started to read it, and you said, "Don't read that to me." Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
It doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. She brought up my daughter missing a day of school. Where did that come from? I mean, all of those have been.
I didn't mention his daughter at all, Your Honor. I'm sorry.
It's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what happened there.
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
I don't
And- Your Honor, Mr. Kelly is retrieving his phone. I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious.
Meritorious defense. You know what? Just take out the word meritorious. What defenses do you have to all of the allegations against you? We don't have to make it special. Meritorious. That's it. And when Miss Dornbush starts talking, man, she rips this guy apart, and it's awesome.
Could you spell it for me?
No.
Okay. See. Oh,
You filed the motion.
yeah, probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
Is it moratorium?
Oh, you know what? I don't like making fun of people. I don't like laughing at people. How do you go from moratorium? Now I can only think of moratorium. Yes, a moratorium defense. That's absolutely what we're talking about. Just look at Judge Simpson. He's like, what? I should have just explained to you what it was. Now we just wasted more time. Oh, jeez. Is that what we did during COVID?
I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay, we can't, no, I was gonna make, I think you should stay too. Go ahead.
When I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have arisen. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. Yeah, if you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I We'll allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm
I didn't say-
I'm gonna try to be fair.
I,
Mr. Kelly,
can I,
step away from the podium?
may I give you a
No,
compliment,
no,
please, Your Honor?
No,
Okay,
do not give me a compliment. Do not say anything to me at this
all
time.
right.
I'm gonna handle Mr. Fink's case as Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's gonna be mad at me.
Yeah, but again, Judge Simpson was on the bench till 6:30 dealing with this guy. All right, I believe this is it. Part 3. Now that I'm saying it out loud, I think this might have been broken up into 4 parts, but I think this is it. I'm pretty sure. This is the longest part. We got about 15 minutes of this. Oh, hiccup out of nowhere. Okay, let's go.
River Ridge versus Timothy Kelly. If Ms. Dornbush is.
I am still here, Judge. Yeah.
I've called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, it was always, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a 3-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information belief and all those lists, please, I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running at that, but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh,
Your
I'm sorry, I don't have,
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
thank you.
Okay.
Your Honor, at the outset,
All right, before Miss Dornbush starts talking, I gotta say this. It's about to go down. She rips into him. Let's go.
when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay, and that's not something my client is going to agree to, and I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well because I do have his email address.
Okay, yes. Well, you have the court's permission to do that, understanding what you did.
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and his having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court, and Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night before.
His daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear, and a default judgment was entered against him. And I've referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are least violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states he is to be in compliance with the laws of the state, local ordinance, federal law, and Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor. My client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect.
Hey, Big and Raiders, I'll update you on what's going on. I wanted to wait till after Ms. Dornbush was finished speaking, but she's on a roll right now. It might be 5 more minutes. I just didn't want to let it go too long without acknowledging the Big and Red. Big and, you are awesome, my friend. Thank you so much. Welcome to the Big and Raiders. I'll be back soon to catch you guys up.
To disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I can't talk. I thought you were done. I'm sorry.
You will have an opportunity to respond. But Your Honor, we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd, and Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome, respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Woo! Get it, Miss Dornbush. Yeah, that was awesome. And yeah, someone said that she has a little attitude. I don't remember exactly the comment, but yeah, it's almost 6:30 at this point. She's tired. She wants to go home. It's a Friday, and she's working because of this guy who can't just accept defeat. He didn't show up. He didn't show up to trial. He didn't, and he comes here with all these stories. Nothing with any legal basis. And yeah, Miss Dornbush is done, and she just showed how done with this guy she is. I say good job, Miss Dornbush. All right, Big N, again, thank you so much for the raid. Welcome to the Raiders. No, I have not given the Hailey update yet. I was saving that till the end, and we still have about 15, 20 minutes left of this case and then the Hailey case. So actually just in time. All right. Again, thank you, Big N. I appreciate it. Let's go.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money. I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't, I didn't get to. But, it's kind of hard. I'm trying to follow her. Some of these things, she says that in my answer, I don't explain things. It's kind of general. Well, this stuff doesn't either. It just says that, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, we can all throw out things out there, but what did I say? Who did I say it to? What was it? Because I can remember that conversation and the incident because that coincides with the electrical cord. So, I mean, it's
Yeah, you know where you would have learned all of those facts behind the allegations? Trial. You didn't show up, my friend. You did not show up. Therefore, yeah, you don't know. Sorry, man. That's how it goes. You got defaulted.
I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong. But as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very.
Yeah, Scaff, I'm sorry. I'm starting to get a headache too. I was thinking I was just dehydrated. I just refilled my water. Maybe it is this guy. But while I am paused, Vicky Johnson, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Vicky. And Derval, thank you so much for the generous super chat. I appreciate it because I got more money than brains. All right, I'll take your word on that. But thank you so much. I appreciate it.
The reason that I've been trying to explain to you about the differences in her, her writing me up, or the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it, and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week. It was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, I get home and I'm on this website that I've never seen before. My daughter brings it in, and it's you, and it says contemptuous defendant goes out the back door. And gosh,
Shout out to OSG. This guy found your video, or his daughter found your video, and he just referenced you in Judge Simpson's court. OSG, let's go.
The comments were brutal. I mean, brutal. It's not up anymore, but it was, and my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were ready to. He was my ride. He usually is, and his car's in the driveway right now. It broke down. And I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the court.
No. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court.
With
you can't
her.
Have it both ways.
No, I know. I explained before that what I was going to bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor, may I respond?
Go.
Please.
Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell you where it's going, and I'm not an expert.
You can't tell anything about it.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision. So I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, that was just meant that I made that decision after I couldn't find a ride. But I haven't skipped your court dates. I'm looking to save my house. I mean, and it's not necessarily,
Mr. Kelly.
It's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm going to stop you because
okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
Okay,
I have good cause for my failure to appear. I did not appear / answer because, colon, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Said nothing about her coming to the court as though you just represented to the court. You didn't come because of her.
may,
I'm done.
I don't
I'm
have it by
done.
memory. Your
I'm
Honor.
so done.
Please, Your Honor, I
Kelly.
just wanted to.
Mr. Kelly,
You're gonna tow my house away with all my possessions? Not you.
Mr. Kelly, I am going to follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff. I've listened to you.
Please give me a trial, Your Honor.
Please give me a trial. You had one. You didn't show up. And you don't have a good reason why you didn't show up. So you're not going to get another one. And I love that Mr. Allen just knows when Judge Simpson's starting to get to that point. And he's like, I'm just going to go stand behind him. I'm expecting the Mr. Allen. So maybe he's just getting his steps in. I don't know. He's been standing at one spot for a minute. But yeah, he doesn't usually get a Mr. Allen during a landlord-tenant case. All right, this is almost finished though. But yeah, Judge Simpson, no was right. Judge Simpson's about to go off now. It's his turn.
Please.
All right, Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day.
I know.
They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I tried my best.
You know
I'm
what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 District Court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody. I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant, and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that because of that you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is the retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your motion to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ.
All right. Oh, I think the best part of that entire hearing, next to the moratorium defense joke, was Mr. Allen just taking the headphones off that guy. He's like, "No, you're gone, man. Go. You've already made all of us stay till 6:30. Just get out of here." And I saw your name pop up, and I'm like, I have a feeling I'm gonna have to pronounce this. Ascalis Wankulo. Anyways, thank you so much for the 3 months. I appreciate it, my friend. Thank you. Yeah, I started this comment. For those of you that came in late, Judge Simpson asked him for a meritorious defense, and he didn't know what it was. He's like, "Can you spell that for me? Can I Google it? I don't know what a meritorious defense is." So Judge Simpson said, "Fine, you can Google it." And he comes back and like, "Oh, moratorium defense? Like during COVID? Do I get money for that?" Like, what? No, huh? So it's a joke. It was good. All right. Oh, all right. Let's move on. Last clip of the evening. This is the Hailey clip. She was in Judge Simpson's courtroom today. And good news, it is over. It's over. I'm going to play it. Chrissy G, thank you so much for the 2 months. Thank you. I appreciate it. All right. I'm going to play this clip in its entirety. I'm going to pause it at the end and talk about it a little bit. But I'm just going to play it real quick, especially because I just spoiled it. I'm sorry. But let's go.
Case of Spice Street Apartments versus Hailey Salisbury. And Gavin Westlaw. Hailey.
For the record,
Hello.
Rachel Dornbush, Palace Law on behalf of plaintiff, Your Honor.
All right, you were to make some decisions. What are we doing?
Well, let me just start, Your
Go
Honor,
ahead.
by just saying we're prepared to dismiss this case. My client has received the escrow check. Ms. Salisbury's rent is paid in full and then some. And so I don't know that the exact dollar amount will get her through December because the water sewer charge isn't exact, but it should be pretty close. And then I believe following this, Ms. Salisbury and property manager can discuss her options going forward and what her intentions are now that everything's caught up.
That's your understanding, young lady? Okay. All right, then what I'm going to do, I'm going to dismiss this case. All right. That's without prejudice. I'm going to order that the trust balance be refunded to the defendant in this case. Well, to specifically to you. Okay. So since we have two defendants on here, Miss Welding, can we make sure that they're clear? I'm going to put it in the file that it will be to Hailey. That being defendant one.
Yeah, it's posted correctly, so.
It's posted to, it's posted to her, so if I just tell them to refund it, they'll only give it to her. All right. Hailey, good luck to you.
Thank you.
Uh,
Do I go over there to the clerk
And get a check?
and ask them, or
Sure, you can ask them. They're probably not gonna
Oh,
they're
yeah.
not gonna write you out a check today, but
is that how it works though, or do I need to do anything?
yeah, they'll either give you a check or mail it out to her, right?
They will mail it.
Okay.
They'll probably cut it sometime next week.
Next week, and they'll mail it to you, okay?
Mhm.
It's good?
Mhm.
Hailey, do me a favor. Take care of yourself, please.
I will.
All right, be happy, and always realize that with all the dark things and everything that happen in the world, that there comes a point where sometimes good things can happen, and you just never give up faith.
Mhm.
All right?
Okay. Thank
Take
you.
care.
You too.
All right. All right. That's it. That's the end of Hailey's case. It was dismissed. All the money was used. It was sent to the landlord. She got the rest of the escrow back. She is done with the courts. Good for her. Good for her. Giant shout out to everybody that helped. This was an amazing story. Happy to see it. I'm happy to see it's over. I am. I know everyone involved they were tired. They were tired of going back and forth to court. I can tell you the hearing they had 2 weeks ago, when the money wasn't released from escrow, you could tell they were tired, and they did not want to come back to court today. And yeah, they did. Well, Hailey did. No one else did. Sorry, Hailey. But yeah, Andrea, I talked to Andrea, and she's like, "Do you think I need to go?" And I'm like, honestly, you being there is not going to change anything. The outcome's already done. They got the money, and I told her exactly what was going to happen. So yeah, but yeah, there we go. It's over. But I don't really have anything else to add. Besides the little bit I talked to Andrea, since I wasn't there and she wasn't there, I don't have any insight from what Hailey said or what she was thinking. I did ask Andrea to check on her to make sure she was okay, but I didn't hear back from her after that point, so I don't know. So hopefully she's happy and she's having a great night. Derval, was this before? Yeah, no, this actually was in the middle. It was in the middle of everything. I think the first part of Mr. Kelly's hearing was before this, and then her. No, wait, her case might have been between part 2 and 3. So I feel like because she was in court, you could see her every time they panned up, but she wasn't there at the last part. But they did call her case at about 4:30 when it was supposed to be called at 2. So yeah, long day for her. Okay. What else was I going to say? someone asked, did Gavin get his name taken off the lease? That's something they can talk about now. The apartment complex did say they would work with him after the balance was taken down to zero, but they weren't going to touch the lease until the balance was zero. So hopefully they get the name. Hopefully they take his name off. I don't see why they wouldn't, especially now that she can pay the entire year's rent. So, and she might be leaving. They might let her leave. It's up to her now. Her story is in her hands. So we got another super chat. Chrissy G, hey, Colin, love your chat. Thank you so much, Chrissy G. I appreciate it. Thank you so much for the super chat. Thank you. Okay. Yeah. Again, I don't really have anything to add. Andrea's happy it's over. That's really all I know. And Hailey's bouncing her way out of there. She's like, I'm out of here. Okay. But with that, the stream is over, guys. The stream is over. Let's see who we can raid. Who do we want to raid? I gotta see what the options are. Lone Wolf, KCC, or Mark? I've rated Lone Wolf. I rated Lone Wolf. Let's do KCC. I haven't rated KCC in a while. Let's see what KCC's up to tonight. All right. You guys are all awesome. Thank you so much for hanging out with me tonight. Thank you so much for the raid, the Big In Raiders. You guys are awesome. Thank you everyone for the super chats, the gifted memberships, the membership milestones. You guys are all truly awesome. I appreciate it. One bit of news. The Bengals play on Sunday night this week. So I will not be streaming Sunday night and tomorrow night state night. So I am not going to see you guys again until Monday. So I really hope you guys have a great weekend. Stay safe. Don't do anything dumb. I will cover you. Trust me. Don't be a Mr. Kelly. You're gonna end up on OSU's channel too. Not a good look. Not a good look. Before I bounce, Purple Dragon Shield. Thank you so much, Karen. I appreciate it. Member for 4 months. That is awesome. Thank you so much. Thank you. Okay. Let's go. We're rating KCC. Make sure you tell her I said hello. Lone Wolf is also live, and so is Mark, the sarcastic law student. So those are your three options, at least on my list right now. I don't see anyone else live. So take your pick, go have fun, and I will see you guys on Monday. Until next time, bye.
Spice Tree Apartments versus